That's
No, that's
small.
right.
It's a small one. It's a long time ago.
Yes, but I
Okay.
apologize, I do apologize.
I did read everything more than
Yes.
once.
No,
Okay.
thank you very much. I appreciate being.
Okay, unless I'm reading it wrong.
Well, that's actually, it's expunged.
Okay.
So I can say I
It's-
have it.
It's old.
Thank you. Your Honor, in the case, he had prior counsel. He was serving a subpoena, lawfully serving a subpoena. And there were allegations with a woman that I guess there were some political ramifications going on that misdemeanor charges were brought. Mr. Robbins had a prior attorney at the time. The bail was originally set at $500,000 prior to my entry into the case. Subsequent or prior to my entry again into the case, a bail review motion was done, at which time the bail was reduced to $20,000. We have a videotape of the conditions of what, there were reasons, I'm not going to get into the high bail, I think there was some concerns. Nevertheless, the bail was reduced to $20,000. I get a call from Mr. Robbins who says I had an attorney. I asked him to try to disqualify the judge. Would you please take my case? And I did. No plea had been taken. At that point, I find out that Mr. Robbins, who lives on the California side of Lake Tahoe, after the bail was reduced, he had done some jail time, was up at the lake, was informed through court services of conditions that he had to drive down every day on misdemeanor to report to court services as a condition of his bail, which Mr. Robbins has told me was never a condition. And they issued a warrant on something that he is adamant about was never a condition of his release. I didn't know that. I didn't know the tape shows that there was no conditions of his having to report to court services. If that's true, that's an issue that is relevant, I guess, in these arguments.
Actually, I don't think it is. It goes to the contempt of court that was already been addressed on the video I saw by Judge Tatro. And you're going backwards on me. The only thing you're here today for is the Department of Alternative Sentencing allegation that there's a violation of the conditions of his possible dismissal in this case.
Yeah, that brings me, so okay, when I came in on the case, Mr. Lucia and myself discussed the case. They dismissed the assault. We deferred entry for a year. And I had Martha Mahaffey, who's very respected in Reno by the district attorney's office, do an evaluation. We all agreed. I've spoken to Martha Mahaffey. Martha Mahaffey made numerous findings. No evident violent ideas, no known access. I mean, she made numerous findings in the case.
I did read it. It's a 14-page report, and it's very, very well
She's
written.
excellent. She's fantastic. Her husband was a DA. The DAs all trust her, and that's one of the reasons I used her in the case.
That was
I
smart.
respect her very much.
Okay?
Now, we had that evaluation done. And so that evaluation, I think, was helpful. And Travis, Mr. Lucia, and I saying, okay, look, we'll do a deferred entry for a year on a disturbing the peace. We come to sentencing at that time, and the judge throws him in jail, has him do contempt of court, which wasn't a part of our deal, was unexpected. It's a reality that happened. He did his time. He got released.
You're referring to the extra 9 days on the contempt of court issue. Okay.
Right. So we're here today, and here's the great concern that I have. The Department of Alternative Sentencing is in no way involved in the agreement between the prosecution and myself on a deferred entry. As far as I've ever known, I've never had. He is neither on supervision. He is voluntarily, as a condition of a deferred entry, willing to jump through the agreement that the prosecution and myself agreed to, and the judge was on board with that agreement. So when Mr. Lucia and I spoke, I said I'm really concerned that they would even get involved in this. They don't have any involvement in this case. And I don't understand why I wasn't given a copy of this document prior to today. And I don't understand, frankly, Judge, why they get involved in something in which they're not a party. So I'd ask the court not to consider the request that they made, because I don't think that they have any right to put themselves into an agreement that was agreed to by the three parties here, or Judge Tatro. Then, the treatment recommendations that were issued at sentencing, or the deferred entry, which really.
Well, why don't I, before we go forward, let me ask the city attorney, Ms. Lucia, to explain to me how the Department of Alternative Sentencing works, because we don't have that particular agency in the South.
Right, Your Honor.
And what is their function, so I understand.
Essentially, the way that I understand it, and I know I saw Chief Flynn here earlier, I mean, he could probably shed a little bit better light on it, but basically the way I understand it is, in essence, DAS operates along the same sort of vein as parole and probation, only on the misdemeanor scale. Through that, they're essentially an arm of the court to ensure compliance with certain court orders. Now, that might be through imposition of like a suspended sentence with, for example, if it was a drug paraphernalia case, on a no alcohol or drugs clause, DAS might act as a sort of probation officer, parole officer for individuals who are checking in to submit to search and seizure for, alcohol use, drug use, and the like. So the way I view DAS is actually, I guess, describe it, is almost like an arm of the court. So as far as their involvement in this case, I don't think that there's any other avenue by which the court can enforce its orders or become aware of certain things without having DAS's supervision. Certainly the DA's office wouldn't take that role as an investigator, because then in essence we'd be investigating the very cases we prosecute, rendering ourselves subject to subpoena for issues far and wide. I mean, we'd essentially be conflicting ourselves off of each and every single case that we take by doing it that way.
Let me ask you this, I've never seen a report like this because we don't have this agency in the
Right.
South. So is this a typical report on a misdemeanor case, whether it's conviction or deferred?
It's very typical. I mean, and I can say personally that I've seen those exact kind of reports on a wide variety of
Like how many times?
That just depends on the individual.
No, I mean during your career, have you seen it once, twice, 1,000, 500, I don't know.
I've been here for roughly 14 months. I mean, on every Wednesday morning, we do roughly 50 pretrial cases. On average, I'd say about 35 out of those 50 resolve. Most likely, those people are placed on suspended sentences because they're misdemeanors of certain half. And then on those cases, the average time that a person might violate and justify a report being generated like that can run the gamut, quite frankly. Just more frequently, of course, we see it with people that are on supervision with DAS for things related to drugs and substance abuse, because they're the ones that are coming to check in. Typically, they check in either daily. Sometimes they'll put people on what's called color-coded testing. At that point, the probationer has to call into the DAS offices. They'll give them a random color, and then if that color's called, they have to come down and test.
So you see this all the time, is what you're trying to tell me?
For lack of a better word, Judge. And what's different about this one, and quite honestly, I mean, in situations that I've seen in the past, when a person's violated a condition of either a deferred sentence or a suspended sentence, if the officers think they have cause to arrest the probationer, they'll arrest them right there on the spot. It's a rarity, I think, when a report is generated to just address an issue at a status review hearing like this one. Typically, in my experience, if the DAS feels that somebody's violating an order that the court gave them, then they'll arrest them and a report will be generated and the person will be usually seen in custody.
Okay, but in this case, it has filed a violation report.
I can say off the top of my head, I can specifically, in addition to this instance, I can specifically think of maybe 3 other times where there was a violation report generated, yet the individual was just kind of summoned to court at a later time to address it, that they weren't remanded right there in custody.
Okay, well, I'm going to allow it to proceed as is. That was counselor's first objection, so you may continue with your future.
Yes, Your Honor. If I can make a clarification on that. DAS, it's like reporting to a probation officer if someone's not on probation. In every circumstance that the prosecution deals with DAS, it's never a circumstance where he's not on probation, he's not under...
He's on informal probation. He has a chance to get this case dismissed. And that's a good deal. And I think he probably still wants that.
But I don't, in all due respect, I don't see it as informal probation.
Okay, well, you don't and I do. You may continue with your argument, though.
Thank you. In any event, Judge, so I was in court pending in front of Tate 12 months ago, and on a matter unrelated to Todd Robin. And if we have to call the judge and the DA, I'd be more than happy to do so, because this is what's concerned me in this case. And this here today